Good afternoon, everybody, and welcome to this latest NEC Users Group Conference Workshop. Welcome from me, Patrick Waterhouse, and from David Hunter. And we will be presenting, hopefully, for about the next hour on the subject of delay damages in NEC contracts, and with particular reference to the more recent changes. We have a number of questions already submitted from people, and we have our presentation coming up shortly to enable you to see what we're talking about. And if you have any further questions that come up in the course of today, then please use the chat function to leave them, and we will hopefully have some time left at the end of today for those to be answered. So, David, I am struggling to see the presentation at the moment. Is it up?
David, you're on mute.
I beg your pardon. It's showing on my screen, Patrick. I'm going to unshare and reshare again to see if that makes any difference. So bear with me.
Cheryl, can you see it?
Oh, I can see it. Yeah, I can see it.
Oh dear, just let me play around, see what I can do here to make it. May well be me. Right, I think by the sound of it, Cheryl and David, I'm the problem. I will leave and come straight back in.
No problem. The audience can see it, so we're good.
Just perhaps while we're waiting for Patrick to log off and come back in again, rather than we don't waste too much time with that, a little bit of housekeeping. We'll just ask for today's session that you can disable your webcam and your microphone. I think most people seem to have done that. I see Patrick has now joined us again. Patrick, I was just filling in for while you were away, doing a bit of housekeeping. Are you able to see the slides now? You're on mute, Patrick.
Yes, thank you. I can see and I can hear, and hopefully you can do likewise with me. Apologies everyone for that. I don't know what went wrong.
No problem. Patrick, I'm sort of halfway through doing the housekeeping bit. I guess if I just finish off while you get your bits and pieces together, yeah. And then we're all good to go, I think.
Okay.
So yeah, as Patrick was saying, questions can be asked through the meeting chat. So please do that. Get involved today. Webinar's being recorded, as you know, and you may have seen us do before on other conferences. We're using this app, VVox app, and we've got 8 intriguing, or we hope they're intriguing anyway, polls or questions to be put to you through the course of the session. I'm just going to go back a section. Patrick, I think you're going to do a little bit about sort of the new book, and there'll be another slide on the VVox app. But if you do want to join us, all you need to do is simply through your mobile phone, smartphone, or tablet, similar device, find VVox, download the app and use it if you want to, but you don't have to use the app. And there's a 9-digit number you can see at the bottom of the slide. Just simply type that in and you will see our polls coming up. Patrick, are you okay to hand back to you now? I'll continue driving the slides as we go.
Okay, thank you, David. Yep, I'm back. So this is a a book that I co-wrote with Robert Gerard. Its title tells you what's inside the tin, so no need to explain what it's about. And as with a number of ICE publishing books on NEC contracts, there is a 10% saving for the next month if you use the code you can see there, NEC Books 10, and that's exclusive to those of you attending today. So thank you, David. And hopefully you've all now gone to vvox.app and stuck in your ID. As David said, we've got 8 questions, some of which are slightly more serious than others. You'll see what we mean as we get to them. And so moving on. This is what we're hoping to do today. So we're going to talk about delay damages, and that's obviously a title that comes out of NEC contracts. They're not usually called that elsewhere. Within NEC contracts, wherever there is a time obligation for somebody to do something by a particular date, there is usually a sanction for their failure to do that. And when it comes to the contractor not completing either a section of the works or the whole of the works by a stated completion date, provided option X7 has been included in the contract, there will be specified damages for that failure in the contract. NEC contracts don't exist in a vacuum, so we need to understand the legal position outside of the contract, and we'll be talking today primarily about England and Wales, because that's all that David and I really know about in any detail. And we're going to look particularly at delayed damages in the event of termination, because that's where clause X7 has recently been amended by NEC to suit the development in case law that came about last year, and that hasn't yet been put to bed properly, and we'll explain what we mean by that. We'll look at how clients should set the amount of delayed damages, how they should go into the contract data, and then we'll look at delayed damages in a term service contract. Now, as a service contract, in its normal performance, there's usually not a completion date pegged to something being completed, because in service contracts that's not usually happening. But within the term service contract, there are opportunities for the contractor to be given what you might call a project to do. The contract calls it task orders, and you'll see also we'll touch briefly on the new NEC facilities management contracts, which have some similar provisions in. So there's potentially delay damages in there. We're going to look at applying delay damages. You may wonder why that's a question. Well, in a number of projects that we work on, delay damages, do we apply them, yes or no, even in the event we're fully entitled to them, is often a question that clients ask themselves and their advisors. And then we'll look at key dates. Key dates don't use delay damages in terms of option X7, but the failure of the contractor to achieve what we call a condition by a key date can actually lead to damages being paid by the contractor to the client for that failure. And then hopefully towards the end, we will have sufficient time for some additional questions. So we have here, just to see who we've got round our virtual table, which party do you normally represent? So if you could press 1, 2, 3, or 4 in the closest match to those names, and we'll see who we've got here. We seem to have a don't know at the moment. No, you've closed it. Whoa, look at that. That's impressive. I think if we don't, oh, somebody's just said they can't join the poll, David.
Okay, I mean, I don't think we're going to fix that online at the moment. If you do want to vote and just give your sort of a position, just do that through the meeting chat. We'll try and pick it up. The polls generally do work. We've got some results that will come up here. So use the meeting app. You should be okay.
No worries. It's not critical, but I just said sorry, unable to join the session right now. Please try again later. And I'm trying to join from the browser. So I don't know, maybe it's a browser versus app situation, but yeah.
Try again. We've got some more polls coming up. So,
But overwhelmingly, we are 3/4 of the audience today are people who are actually involved in the contracts, and 22% of the people who are advising those people. And if we'd known we're having that many lawyers along, we could have possibly charged a little bit more, but there you go. Okay, David, let's move on. So what are delayed damages? They are a remedy for the breach of contract, which is the failure by the contractor to complete the work required by the date required in the contract. The phrase liquidated and ascertained damages is often used in law generally, and the ascertained bit is recognising that the amount of the damages is agreed by the parties in advance and is then fixed. And that often suits both parties. It saves them having a huge argument and a dispute about the true level of the losses caused by the breach. In the event that damages are at large, it means that both parties go into the contract understanding their financial position in the event of delay. Just hang on, David. Go back. So it says there it's common practice in construction contracts since the 19th century. For those of you who were at work in 1838, you may remember the case of Home versus Guppy, one of the first ones on this subject. And once the clause is agreed, and assuming it meets the further obligations that we're going to come on to discuss, the client does then not have to prove its loss. The fact the contractor has finished 4 weeks late means that 4 weeks times whatever the weekly rate of damages was is now due. And so the contractor will know its liability in the event of such a breach. And sometimes we see with contractors that if their project's running late, then they can calculate before completion. If I finish, for instance, 10 weeks late, I know it's going to cost me X. And if it's going to cost me more than X to bring this project round and get it finished on time, it's therefore not worth doing it. And there's often some extremely cynical calculations done by that, but it potentially suits the contractor to know what the damage will be in the event of late completion. So where do NEC contracts talk about delayed damages? Well, primarily, we're going to talk today about damages for late completion in the engineering and construction contract. It uses secondary option X7. One of the benefits of the NEC suite of contracts, you may know, is that the option numbers are the same throughout each of the contracts in the suite. We don't call these damages liquidated damages because in the ECC there are actually two sets of liquidated damages. One for low performance, you can see there X17, and one for late completion in the form of X7. And they are each named after the breach of contract that they apply to. Within the short form contracts, as part of their simplicity, there are no secondary option clauses, but delayed damages are included, and you can see the reference there. I think that's in the engineering and construction short contract. The term service contract is different for reasons we'll explain a bit later. Within the alliance contract, there aren't delayed damages, but there is the use of a performance table which sets targets which then lead to adjustments to payments. And in the facilities management contract, which is currently out for sale in I think they call it the pre-publication version. We have things called project orders in secondary option X27, and they can include delayed damages where appropriate. So how do delayed damages link to something that elsewhere we would call extensions of time? And for ease of explanation, we will do here as well. We extend the time allowed in NEC contracts by delaying the completion date. The completion date you can see there, capital C, capital D, is the date which at any time is the date by which the contractor is required to either complete all of the works or a defined section of the works. And where we have an event that potentially entitles the contractor to additional time. Typically, that's a compensation event. We assess the additional time with respect to the accepted programme, and you can see there that's in clause 63.5. Now, as a matter of law, you can't apply delay damages in a contract if there isn't a mechanism for extending the time where the client either is responsible for part of the delay or that delay is something that is part of the client's risk. So it's important in any contract where we have specified completion dates and liquidated damages that we have a mechanism for extending the time for those matters which are at the client's risk. And you'll see there, a bit more recent than the previous case we mentioned to you, Peake versus McKinney from about 50 years ago, is what we still call the modern authority on prevention. That meaning the contractor being prevented from completing the works on time by something that the client is responsible for. So the current legal position, and there's several slides here. So when we talk about the current position, you see a court case in 1915. Believe me, there is something slightly more recently than that. The general position for damages for breach of contract is that there can be no penalty against the offending party. They are merely required to compensate the innocent party for the effect of the breach. And that rule applies to liquidated damages as much as it does to damages being at large. And we've got several hundred years of case law. If you ever think that the industry at the moment is confrontational and obsessed with disputes and so on, look back at the construction of the turnpike roads, the canals and the railways in several hundred years ago. You'll see it was all happening then as well. And we have the dichotomy of the ability to be free to enter into contract and to agree the terms of the contract yourself, and also the principles of equitable relief. And so in 1915, for those of you who've done any of your legal training, you'll know about Dunlop versus New Garage. And this came up with the phrase that we rely on repeatedly even now, a pre-estimate of loss. The amount that you set as liquidated damages for anything has to be a genuine pre-estimate of the likely loss that will be suffered in the event of the breach. And in 1993, you can see that those principles were restated, and I think that is where the phrase genuine pre-estimate of loss came in. So something slightly more recent, and for those of you who've ever been on the receiving end of one of these tickets, you may, like me, struggle to look at this case impartially and fairly and be somewhat disappointed that the parking company was successful here. But anyway, we'll try and explain this as reasonably as we can. Mr. Beavis parked his car somewhere where it said you can park here free for 2 hours, and then after the 2 hours is up, the intention being we want you to leave within 2 hours, there will be an £85 parking charge. If you've ever parked in a lot of places, particularly retail places in town centres, you'll have seen these signs. If you stop at service stations, they tend to say this. And they always, when you look at the acerbic wording on the signs, they always avoid using words like fine or penalty, because there's a real struggle to enforce something in a civil law matter that's a fine or a penalty. You get fined or penalised in the criminal courts, but not when you're parking at Tesco's. Now, Mr. Beavis overstayed his welcome by, I think it was something like 23 minutes. And he therefore got one of those charming letters through the post with 2 photographs of his car and his number plate saying, "We've gotcha, you owe us 85 quid. And he wrote back and said, "No, I don't. That's a penalty. It's unenforceable. I'm not having any of this." Fast forward several months, and Mr. Beavis and Parking Eye found themselves in the Supreme Court, being heard alongside another case in a commercial law case between, I think it's Cavendish Square Management and McDessie, and the Supreme Court considered the issue of liquidated damages and whether something was a charge, a fine or a penalty. And the judges decided that Parking Eye could recover this £85 charge. They didn't have to demonstrate that this chap's failure to leave after 2 hours caused £85 of damages, but they did say that when you run a car park like that, you have to have a system of enforcement, and the people who should really pay for it are those who break the rules. So the Supreme Court decided there was no direct loss, but there could be indirect loss for the car park owners and here their operators. And I think as we see now, the current legal position, the £85 charge was viewed by the judges as not being a penalty. It could be used, as you can see here, to act as a deterrent and to serve, I think it said, the genuine legitimate business interests of the injured party, in other words, the car park owner. But the Supreme Court said the charge wasn't a penalty, and it then set out a new test. And so, does the clause impose a detriment on the contract breaker out of all proportion to any legitimate interest of the innocent party in the enforcement of the primary obligation? In this case, they decided not. But the court did not dismiss the original test from Dunlop in 1915, and they said that they could be perfectly adequate to determine the validity. And the court held that the charge was in proportion to the commercial interest of Parking Eye. So the one thing you should take away from today is these people mean business, and bolstered by case law, they're likely to come after you if you break their rules. So our second question, in Parking Eye, the Supreme Court decided that it was not a penalty, the £85, and therefore was enforceable. Do you agree with the judges? Oh, you fixed that, David. So, this is one of those questions where you shouldn't let anything as ridiculous as morals or common sense get in the way of a good legal answer. I don't know if any of you were watching the Wales against Italy game in Euros yesterday, when the Welsh player got sent off for a foul, and they consulted a retired referee and they said, should that have been a sending off? He said, yes, absolutely. There's a UEFA directive for this tournament. You get sent off for that. And all of the ex-pros and the experts, so-called, said, oh, no, that's not a red card, not in my view. They were letting their morals and their common sense get in the way of looking at what the rules actually said. So I think that's a terrific answer, David, 50-50. So we're now going to look at the changes to clause X7 that happened in October last year. Now, just to explain, in case you weren't aware, NEC 4 was first published in June 2017. There were a small number of changes in January 2019 and a small number of changes, as you can see here, in October 2020. When you are putting contracts together, for those of you who do that, make sure that in your contract data part 1 and any reference you have in the form of agreement or in tender documents makes clear reference to which version of the contract you're using. And clearly our advice would be, as of today, you make sure you incorporate the January 2019 and the October 2020 changes. So one of the changes that was made at the end of last year was the one you can see underlined in red on your screen. And this is an additional bullet that has been added to the clause. As you can see, previously it said that the contractor paid delayed damages at the rate stated from the completion date, in other words, from the date when the parties had agreed they should be finished, until the earlier of either completion, when they are finished, or the earlier of the date on which the client takes over the works. Now, that presupposed that in the event of the contractor running late it would actually achieve completion at some point. But as many of you may well know, we do have situations where, for reasons of incompetence, insolvency, relationship breakdown, and so on, contractors that are running late are removed from the project before they actually reach completion. And this begged the question as to how long you could, as a client, take your delay damages. Could you do it until the date of termination, until the date somebody else completed the works? Well, this was considered in the case you can see in a third bullet point here at the moment, in triple point versus PTT. And this, to a certain extent, what the judges decided here was based on the specifics of that clause, of that particular contract rather, but there was a certain amount for drafters of contract forms and particularly standard forms to take away, hence the reason that NEC published amendments to clause X7. So the contractor is now liable for delay damages that accrue until termination. The liability for further delay damages ceases on termination. Now, the termination provisions in NEC contracts look deceptively simple. Termination is rarely a matter of accord and harmony. Occasionally the parties do mutually agree to draw a line under their relationship and go their second ways, but frequently they are in bitter dispute at the time this happens. So to a certain extent, waiting until we have a termination certificate presupposes the parties are going to follow the termination provisions in the contract and not follow their termination possibilities elsewhere in law. Now, the triple point case looked at delay damages being deducted up to completion, after completion, and the generally accepted position prior to triple point was that they could be still collected after completion. In the triple point case, and remember it's a specific contract they were looking at, the Court of Appeal in England and Wales suggested that the delay damages that had accrued before termination could fall away in the event of termination. Now, you can see here that the Supreme Court has already heard an appeal from the Court of Appeal. It heard it last November. I checked the Supreme Court website about half an hour ago, just in case we might get caught out, and they still haven't published their judgment on the appeal. We are obviously hoping that whatever they decide sits comfortably with the revised words from October 2020 that were put into the X7 clause. So I think this is the point where I hand over. Is it, David, to you?
It is indeed. It is indeed. Thanks, Patrick. Excellent. I'm just looking at the screen here, and I noticed that we are almost 72 strong in terms of participants. That's including myself and Patrick, of course. I noticed from the polls, it may be a question of connectivity and access, I don't know, but about 29, 30 people had managed to get involved with the poll surveys. So if you are interested in contributing to the session today, we do have some more poll questions come up. Seems to be some good advice in the chat box there regarding using a separate web-enabled device. And yes, there's the 9-digit code at the bottom of the screen. Other ways to get involved in today's session, as Patrick said from the outset, is to put your questions in the meeting chat. We're seeing some questions come through as Patrick was talking. One from Stephen there. Steve, we will get to your question towards the end, but your specific question may be answered. I don't know. I'm going to be talking at some point about the issue of exclusive remedy. So interesting comment that you've made. We'll come to that at the end in the main Q&A session. So yeah, picking up the reins here on the subject, setting the amount of damages or delay damages. And this is typically something that the client would do, or the contractor might do for a subcontract. And the client is essentially looking at, or should be considering, what is the loss that they may incur, financial loss they may incur from the breach of contract, which is contractor finishes late, doesn't complete by the completion date. And we start to get into the question of looking at direct and indirect losses, sometimes called consequential losses. And there's a very well-known case back to the 19th century, Hadley and Baxendale. I won't go into the details of it. Have a look at it. It's quite interesting. It's about a mill owner and problems with the late transportation of a crankshaft, giving problems for resuming the operation of the mill in the time that they wanted. But this particular case, it gave rise to what we now know as the first and second limbs of loss. The first limb being that which is a direct loss. So when you're looking at putting together your assessment of what delayed damages, so what losses the client may incur, there's some examples there. Obviously, the client's project management team, you could have the services of an NEC project manager or supervisor, your internal teams, temporary accommodation, facilities, and so on. Slightly more difficult to assess, or certainly in terms of quantifying, what we call the indirect or consequential losses. And this is what from Hadley and Baxendale, we have this term, the second limb. It's a question of remoteness. We don't, I think I'm right in saying, we don't worry too much about remoteness when assessing or calculating delay damages, because they are pre-agreed and they're fixed. And providing they're not unreasonable and don't fall foul of some of the issues that Patrick talked about in terms of how the law addresses these matters, we don't have to worry too much about whether they come in as direct or indirect losses. But some things to think about. Typical items might be business interruption, a loss of profit or unrealized profit. Many contracts or projects for a client will involve third parties, and within that third party agreements, funders, banks, other interested parties, landowners, and such like. And indeed, from those third party agreements, as the agreements that the client has with others, failure to complete their project on time or return a certain part of a land to a particular condition, that in itself may lead to costs or damages that the client has to pay to others. So all these things have to be considered when assessing what should be the rate for delayed damages in your contract with the contractor. But we need to find the balance, because as we know, if the client sets the damages at a rate that is too high, the terms of the contract may be unattractive to the market, to contractors. It may mean that the contractors will put in a premium, a higher price to undertake the works for that level of risk, or indeed may decide that they don't wish to tender or get involved at all. Set the damages too low, and then we might find that the client is not able to recover all of the losses that they potentially could incur beyond what the rate for delay damages have been stated. One way, of course, to reduce this risk for the client is by setting a realistic timetable to start with. Later on in the slide, we'll be looking at how we complete contract data and different ways of approaching the matters of who decides the completion date. But of course, if we set a realistic timetable to start with, something that's achievable, we can achieve completion by the completion date, then the question of delay damages would not but why is it overriding? It's worth to note that delay damages are not part of any cap on liability. So those of you familiar with NEC contract, we have the secondary option X18, and that's a means by which the contractor can cap or have a limitation on their total liability. There's some subcaps there as well. But delay damages is one of a number of items listed that are excluded from that total limitation of liability. So X7 delay damages are not part of that calculation. And that's as much important to note for the client as, of course, is for the contractor. When the contractor is considering what their overall potential exposure and limitation or level of liability is for non-performance under the contract. Okay, we have our third poll question. Do you think that liquidated delay damages, at the NEC term, of course, are effective compensation for most clients? A simple yes or no as the first option's binary yes or no, and the third one depends on the rate. Do you think that liquidated delay damages are an effective compensation for most clients? Okay, just seeing responses. We've got 31 out of 31, so we'll close the poll and we'll see. Yeah. Well, actually, in some ways, I would have expected their number 3 to be a bit higher. So I think it's an interesting response. 38% of you believe that delay damages are an effective compensation for most clients. Yeah, and I don't know about you, Patrick, but I was surprised with that result actually.
I think the "it depends" answer is probably the right one, because in the event that your damages are too high or too low, it's only going to suit one of the parties, isn't it? And so if the client wants to have an effective compensation, it will depend on the rate.
Notably, almost 13% people believe that the answer is no, that it's not an effective means. Perhaps that just reflects the different levels or rates of delay damages that people may have had in the past. Okay, excellent. Thank you for responding to that question. I'm going to turn now to preparing contract data. We are very usefully and importantly reminded at the very start of contract data that completion of the data in full, according to the options chosen, is essential to create a complete contract. And I think that's excellent advice. I'm not so sure from a legal point of view that delay damages would be an essential term as such, but no doubt a very important term to get right. The starting point for preparing contract data is that the client has to make a positive decision whether if they're going to choose delay damages, and start by stating in the data entry field there X7. Just as a note, what we're using here is an example is extract from the contract data for the ECC, the engineering construction contract. But the other long forms are similar, if not almost the same in that regard. So having chosen X7 and stated that in contract data at the start, assuming that the client has not decided to use the secondary option X5, which is exceptional completion, then the simple statement is delay damages for completion of the whole of works are, and in this case we've just chosen a nominal £1,000 per day. Note that the unit is per day. I've seen on occasion weeks being used. Per day in NEC terms, unless there is a clause, a Z clause giving it a definition, is calendar days. So in other words, there were 7 days in the week. If the contractor was required to reach completion, so the completion date was say the Friday, and completion was not achieved or certified until the following Monday, there would essentially be 2 days of delay damages accruing. However, we do also need to think about sectional completion. It might be the case that X5 has been chosen, sectional completion is being included in the contract. If that's the case, we have a separate part of the contract data to populate, and indeed, as I was reminded by Patrick when we were preparing this, is that you wouldn't have both. So as you can see, we have a section, a description, and an amount per day, but then the last item on the contract data, when you've got a combination of X7, so delay damages with sectional completion, is delay damages for the remainder of the works are, and that of course would pick up everything that's beyond the sections. A short note here, a question mark, I think that I put against this is be careful with your descriptions of the sections. Okay, there are 2 cases. I'm just looking at the clock now at 20 to 2. Probably don't have a lot of time to talk about them in detail, but at least two that I found anyway, that had problems around either the lack of a description for sectional completion or similar things, which caused problems. Vinci and Boma, that was 2017. That was indeed an NEC contract, option A, I believe, NEC 3. Those of you who might be familiar with it because it involved work at Gatwick Airport, baggage handling system. They included sectional completion and delay damages, but there was a dispute over the scope of work between 2 sections, what was required for section 5, I think it was, and then section 6, an argument over what was included in each section. So Boma, they argued that the delay damages provisions were uncertain, and therefore so the scope of each section was uncertain, so the actual provisions for delay damages were in fact inoperable. In fact, they argued it so well that they managed to convince the adjudicator that was the case. However, Vinci weren't happy, and they did take the matter to court, and hence the court case there that we've got cited. Cut a long story short, the court decided that it was possible to allocate the work between the sections, although it was rather difficult and there was a lot of examination required to do so. So in that case, Boma failed. However, it wasn't without a dispute and problems, and there was certainly uncertainty around it. A slightly different result came from the other case that we've highlighted there, Taylor Woodrow and Barnes and Elliott. That was from 2004. JCT, I think I'm allowed to at least say it once during a session. JCT 98 design and build contract, or contract with contractor design, and the result was different there. The problem was, though, that the parties had failed to complete the appropriate parts of the supplementary part of the sectional completion statement. So what do we do about that for NEC contracts? Well, I suppose we could write something a bit more detailed in the description there, but the advice would be probably to do so in the scope. We can, I've got a reference here with the volume 2 of the user guide. And the advice, of course, is when you're looking at putting a definition for completion, which is normally at our forefront of our minds, don't forget also to do the same for sectional completion. Turning now to a slightly different subject, and going into some more sort of legal analysis on the question of delayed damages. From time to time, we get the question, what does it mean if the contract data has been completed with X7, but there's a statement that says in the box nil, perhaps with the purpose of identifying that delay damages do apply to exclude general damages, but that we don't want to apply any liquidated damages. So the question arises whether or not, indeed in law, it would be seen that delay damages, if included in the contract, so including 6.7, would be what's called as exhaustive remedy. In other words, can we also include apply general damages? This was dealt with in, again, a fairly well-known case, I think. It's got a lot been written about it, from 1987, so 30-odd plus years ago. Temlock and Errol. You might see this sometimes referred to as the Temlock principle. Temlock, Errol, this was the Court of Appeal judgment, and as you can see from the dates, it is pre-NEC. NEC was only just about being thought about then, so before the publication of the consultative edition in 91, and then the new engineering contract as it was then 93. So this was a JCT contract, JCT 80, and the employer in this case, which was Errol Properties, they argued to the courts that by inserting nil meant that the clause in the contract that was dealing with liquidated damages was excluded, so therefore they could claim general or unliquidated damages. They were unsuccessful in their attempt. They didn't persuade the courts. The courts applied what might have been considered at the time a particularly harsh approach, but a literal interpretation of the contract, just enforcing really that the courts won't seek to modify an agreement the parties entered into. Seems no firm ruling, as far as I'm aware, where perhaps the space where you have to put the rate in is left blank, or maybe there's a dash. So Temlock and Errol, nil normally means, I think it's good, still good law, that secondary option X7 delay damages is your exhaustive remedy, so general damages would not apply. Two other cases, one of which is from New Zealand. Just to say, other views have been expressed, so I don't think it never is the last sort of word on these matters. A lot of these things turn on the sort of facts of the particular case, this express wording of the clauses. So I think Temlock and Errol is good, but if you're prone to sort of tinkering with the words in your contract, then you be careful that you might introduce something that is not quite consistent with those decisions. NEC contracts have defined terms, and we define a completion date by pointing to the contract data. The completion date is the completion date, unless later changed in accordance with the contract. And those of you that are drafting convention within the NEC forms will know that text in italics means we're going to go and look at contract data. The obligation on the contractor comes from core clause 3, the obligation to complete on time, clause 30.1 particularly. The contractor does not start work on site until the first access date and does work that completion is on or before the completion date. So the obligation comes from clause 30.1, and you get the completion date from the contract data, unless otherwise changed in accordance with the contract. And typically, the way in which a completion date will be changed, as Patrick mentioned early on in the session, is through the mechanisms of clause 63.5, which talks about the assessment of plan completion, looking at the accepted program and then the impact on completion date. And therefore, we do have a mechanism that avoids this problem with prevention and Peak and McKinney that Patrick referred to earlier. Question though is, who sets the completion date? Well, there are two options or two choices. The client can choose, or the contractor may offer a contract completion date. How do we deal with this within the NEC forms then? Well, it's all about the contract data. If the client has decided that they're going to set the date for completion, then simply in contract data part 1 under the section for time, we populate the data field there. Completion date for the whole works is, it appears to be tomorrow, 22nd of June 2021. But it may be that the approach, the contract strategy that the client is following is that they refer the contractor or the tenders that are bidding for the work to decide or offer a date for completion. And if that is the case, then it is the contractor's part of the contract date, so part 2, where that statement would be written. Now, I have seen, and you may have took an error in contract data where both statements have been included. For some reason, at some point, the drafter had included a date in contract data part 1, the statement, because the contract data is a template where the contractor can offer their date, had been left in the contract, and therefore the contractor decided to populate it. And if you have both populated, and in this case you see 2 different dates, naturally contractors wanting an additional month, then again we have a potential area of uncertainty which we want to avoid. So either way, if the contractor is to have the completion date, offer the completion date, delete what's in contract data part 1 in the client bit, and vice versa as a part 2. To note though that whilst there is an opportunity to for the contractor to state the overall completion date, there isn't anything in contract data to allow the contractor to decide date for sectional completions. I guess by negotiation, perhaps, that could be done, but sectional completion dates, which we can talk about a bit more, will be something that's in contract data part 1, so in the client section. Hey, another pause from me then, and a fourth question, a fourth poll. Do you think that liquidated damages are an effective motivation for contractors? So a slightly different approach to the question we had previously. Do you think liquidated delay damages are an effective motivation for contractors? Motivation in the sense that if they see huge sum of money, damages that they will be responsible for, that would make the contractor go quicker, speed up, make sure they finish on time. Okay, so 31 people, 30 responses, so that's good. I'll just close the poll. Let's see what you have decided. Okay, a yes. Almost it was like spot on. A third of you say yes. No is the 10%, so fairly small portion, but a much higher proportion there. 56%. It depends on the rates. Yeah. It's interesting to see that actually that a high proportion of you do actually believe that the level of delayed damages is sufficient motivation to achieve completion. Interesting. Okay. I think we may have had a question along this line in the chat. I know there was something on social media about a week ago when we were sort of promoting the event. So we'll talk about now about capping delay damages. General advice, I think, is to avoid amending or changing contract data, and one might be minded then to use a Z clause to amend what the secondary option X7.1 says. So you might have something like this. Actually, there's not a lot of the words changed here. We've just added an additional bullet point here. The contractor pays delay damages at the rate stated in the contract data from the completion date for each day until the earlier of. The second, third, and fourth bullet points you'll recognise from the clause itself. And as Patrick talked earlier, we've got this fourth, in this case, additional line about limiting delay damages on termination. But I've included also an earlier date of, in this case, I've just chosen 91 days after the completion date. Of course, choose a longer or shorter period as required. 91 days was, in this case, seemed to be appropriate. Again, note the use of days as opposed to weeks in the use of in the units of time. 91 days, 3 months. When capping delay damages, you might also think about what we want to do with the if secondary option X5 has been checked. So if you've got sectional completion, the way that the contract works by virtue of the what's stated in X5 is that each time there's a reference to completion and the completion date, that also applies to any section of the work. So if you want a different cap, different cap on delay damages, then you might need to expand that clause. Okay, our fifth poll: should delay damages be capped? And a reminder here that they are, of course, as mentioned earlier, an excluded matter under the contractor's total limitation of liability if X18 has been used. A yes/no answer for this one. So I don't know. Can we predict what the answer is going to be? I don't know. I'm going to put myself on a limb here, and I'm going to say yes. Although I think there's a high proportion of clients here on this session today, so we'll see. A few more people been engaged here. 34 of you logged on.
I think there's a third answer, David.
Sorry?
There's a third answer we could have put, which was it depends on which side's paying my fees.
Well, yeah, I guess. Let's see what people have done here. I've got 32 out of 34 responses. I'm desperate to get 34. 33 now. See if things are coming through the wires. Well, let's close the polls anyway. I think we've got a good cohort there, and reveal. Oh, okay. So it's a 60-40 split. I suppose if this was a vote, the The yeses would have it. Couple of more coming in for. I just see on the chat box we've got a couple of people who maybe weren't able to use the poll. Come in with a no, at least one anyway. So yeah, I think not conclusive, but that certainly heading in the direction of a yes. Cap delay damages. Interesting. I wonder if that's something for NEC 5, an option to cap delay damages. Just to follow on from that, then we've got a question. Next question. That's poll number 6. Where you do have sectional completion, do we think delay damages apply to each section, but also apply to completion of the whole of works? This question here is about the fact that you can potentially have almost double damages. So if a contractor is late on completing a section, and the dependency on the program is means that there's a knock-on effect to completion of the whole of the works. Do you think it's right that we effectively get double damages? Simple yes or no with this one. Just waiting for people to vote. Going through, got 30 out of 32 responses, which is good. 31. Okay, let's close the poll, see what we get from this one. Yeah, interesting. I think we've got a lot of clients on the session today, Patrick. Is that the split between clients and contractors?
It was about that. I guess they're all clicking yes in the spirit of mutual trust and cooperation. Yeah.
I guess what it'd be interesting to do is to analyse the results and see where they've come from. Which party was that? Yeah. Okay. Well, let's move on. It is a few minutes after 2 o'clock. We're going to try and get some time for some questions, so I'm going to press on. Yeah, delayed damages, term service contracts. So changing tack slightly, with the TSC term service contract. It's a service contract. There's a service period, so there's no specific completion date for the service, and therefore no delayed damages associated with that. And that's right. That's natural. But if the client wishes to call off work under the BSC, they can do so by task orders. It's the role of the service manager. Under the TSC can do so, and clause 19. And it's where the task order instruction, this is where we see the amount of delayed damages being identified. So it comes in the instruction of the task order, reference there, clause 19.1. Look at the third bullet point, is that the service manager would include the amount of delayed damages for late completion of the task in the instruction of the task order. And of course, this is after the parties have entered into the contract date. We talked previously about delay damages or liquidated damages being pre-agreed, genuine sort of pre-estimate of costs. But it's not really pre-agreed, is it? It's after the contract date. It could be said that the service manager is effectively deciding or imposing delayed damages on a task order by task order basis after the parties have already agreed on the contract. I believe there's a similar approach in the new facilities management contract, where work can be commissioned through the use of secondary option X27, which are titled project orders. So, clause 19, the delay damages in a task order, if any, are not more than the estimated cost to the client of the late completion of the task. that seems to suggest some limitation on what delay damages could be assessed at. A genuine pre-estimate of cost, well, I think it would still have to be, but there's nothing to say that the service manager can't include the things we talked about earlier in terms of the sort of first and second limb of direct and indirect and consequential losses. At this point, of course, the contractor is having to comply with the contract, having to accept any task orders or instructions are given, providing they're given in accordance with the contract. So at this point, does the contractor really have any right opportunity to negotiate on these delay damages that will have been stated in the task order? Perhaps it would be better to include rates for task orders, delay damages in contract data. I have actually done this recently on a TSC. The client would obviously have to understand and know what type of work they're going to be commissioning. Well, one would like to think they would know that. They might not know the detail of the scope of work, but the nature and the type of the work and the consequence of the impact that would happen if the task order was not completed on time. I think most clients should have a good indication of that. So should be able to put forward a genuine pre-estimate, I think, at contract date. So anyway, we haven't got a poll question on this, but perhaps we should have done. Perhaps you can give your thoughts in the meeting chat. But definitely some thought against that question. Would it be better to include rates for the delay damages for task orders in contract data, sort of stage one, so before the term service contract goes into? Turning now to applying delay damages, I'm going to talk in the context of the engineering and construction contractors, mainly because I'm going to be putting up some clauses, but the process is similar. What does it say? Where X 7.1 tells us that the contractor pays, that's the language we use, pays delay damages at rates stated from completion date until completion of takeover. Shortened sentence there. We've also got the issue of termination, but the point is the contractor pays delay damages. Now, for the ECC, it's the project manager. If it was the professional service contract, it would be the service manager. The duty of the project manager is to assess the amount due, so undertake this interim assessment and certify the amount, also undertake the final assessment. And it says within the rules under 50.3 that when the project manager assesses the amount due, they include also amounts to be paid by the contractor. So this is where we get to the point where who applies delay damages? Well, actually, it's the project manager, the person who's assessing payment. But what happens if the client doesn't want to take delay damages? The advice, I think, the best advice is probably that the project managers should still do their job. So let's say the circumstances are that the contractor is in delay, in other words, the completion date has passed, they haven't yet achieved completion, there's been no takeover, and the client has said, well, I don't want to take delay damages, it seems a bit harsh, they're very high, whatever reason, maybe there's other things going on, they want to spark any sort of contentious further arguments or issues at this particular point. Well, the best advice is the project manager should still do their job, still clause 10.1, act as stated, follow what X 7.71, apply the delay damages in their assessment and the certificate. And of course, the client then, if they ultimately don't want to pay the amount that's on the certificate, they can pay something different. Patrick reminded me last week when we were discussing this that, of course, if you're following the YUK2 applying to your contract, so the payment terms aligned to the Construction Act, it reminded me that, of course, there was no such thing as a pay more notice. But nevertheless, I don't see any reason why the client could decide not to. Some issues that perhaps we've not got here as to what happens, does that waive any rights for the client later on? But nevertheless, I think for the advice of the project manager, do the certificate and the client can decide. What happens if the project manager doesn't deduct the delay damages or the approaches that they produce the certificate, but they haven't included that? Well, I think a slightly easier approach is that assuming the project manager has made a mistake, then the client can, of course, pay less. And again, if you're working under the Construction Act and UK2, that pay less notice has to be given in accordance with the clause. And from memory, I think it's no later than 7 days before the file date of payment. It may be the case, particularly if we're not completely on top of caught up with the process for managing change through completion compensation events, that we have already previously applied delay damages, but since then a compensation event has been implemented, which moves the completion date out to a point where the contractor is no longer in delay. Well, simply X 7.2 deals with that, and the situation of the client will have to repay the amount that's been paid by the contractor, deducted from the account, plus interest. Oh, I beg your pardon. I flicked the slide too quickly. Clause 35, we have what we call takeover in NEC contracts. What happens if the client has taken over the works or part of the works before completion? This is a situation that could happen. The project manager is then called upon to make an assessment. They have to make an assessment of what the benefit is to the client in taking over a portion of the work, and then they make this assessment, proportioning down, and a reduction in delay damages is then assessed in that way. Our seventh poll question: should a client take delay damages that have been certified by the project manager when the only cause of delay was something for which the contractor was liable, but not to blame? I think, Patrick, you had a very good example on this. I can't recall which one it is. You mentioned it last week.
It's very common at the moment that there are shortages of materials, that anything that's getting imported is costing a lot more money than it previously did. And when we say a lot more money, we're talking 25 to 50% in cases. This is traditionally a risk contractors take, the price of materials, the price of people, but it's not contractors' fault. There are strange events going on in the world, but these are things that contractually contractors are liable for, but it is not their fault. So occasionally we come across benevolent clients who say, well, in that situation, I'm quite happy not to take liquidated damages.
Okay. About 2/3 of those that are logged on to VVox have voted. So we'll just give a few moments more for those votes to be registered. And we'll see what our participants think of this particular question. Should a client take delay damages that have been certified by the project manager when the only cause of delay was something for which the contractor is liable, but not to blame? It wasn't my fault. I have liability, but it was not my fault. Okay, let's close the poll and we'll see what we got. Yeah, 50-50 almost, I think, give or take. I suppose it really depends on the circumstance, doesn't it? Very, heavily dependent on the circumstances. Perhaps it depends also on what the rate for delay damages are and what the real impact is. Some of these questions we've got are yes, no, sort of quite a binary approach, but perhaps these are things to think about as you go away from the session today. Perhaps the question and getting to think about these things is more important than the outcome of the survey question. Right, key dates and damages. Key dates are different. They're not section of completion or related to the completion date. Key dates are a very useful mechanism within the NEC contracts to allow the client to manage the work of others, programming work that's been done by perhaps a contractor that are appointed directly by the client. In terms of the position on damages, is that through contract data we would state the condition, the thing we want to have complete, and the key date associated with that condition. It's an optional statement, goes in contract data part 1, but there's no fixed damages. It's not like X7 where you put the actual rate in, no fixed damages for a delay in meeting a key date. But the contractor could be liable for damages. Now, we need to look at clause 25.3. I've got the whole of the clause up here to see what it says about these additional costs. If the project manager decides that the work does not meet the conditions stated for a key date by the date stated, and as a result, the client incurs additional cost either in carrying out work or by paying an additional amount to others in carrying out work on the same project, the additional cost which the client has paid or will incur is paid by the contractor. So for the contractor to be liable, there must be a cost incurred by the client, and it's limited to work on that particular project. So you can see there's a limitation in that scope, but not unlimited in terms of any financial caps. We conclude from this that delay damages associated with key dates, although it doesn't use the word delay damages, is probably a form of general damages as opposed to liquidated, because they're not pre-agreed and they're not pre-fixed. There is a sole remedy clause, the last sentence of clause 25.3, which says the client's right to recover the additional cost is only right in these circumstances. So again, you've got a sense that there's whilst it might be general damages, they are fixed associated with the scope and limitation in clause 25.3. Right, I think this is our last question, our last poll, number 8. Is it fair that a contractor can be late in achieving a condition for a key date and for achieving completion and pay 2 different sets of damages? So it's a bit of another sort of double damages type of approach here. If a key date and the dependence in a key date affects other work in the critical path and affects achieving completion, the question is it fair, is it reasonable that the contractor will be liable for both? I think under the contract, they would be. There's nothing to say they wouldn't be. But our question is it fair? And a yes, no, maybe we should have a maybe in there, but a yes or no. 32 of you have logged on to the app. I have 26, 27, increasing number in votes coming in. We'll just give it a second or two to see, get a reasonably full house, and then we'll close the voting. All right, okay, let's close to see what the answer is. Yes, is in, well, 75 to 25. That's Quite convincing, I think. Yeah. A lot of clients on the session today, perhaps. Maybe I'll be unkind, I don't know. Right, that's it in terms of the material that we've got to present. Patrick, have you been tracking some of the questions that are coming through? I think there's been quite a lot of dialogue and questions and people sort of talking to each other as much as questions. I don't know whether we want to try and trawl back and pick a few out.
There are quite a few good ones. I think I'll start off with one that came in from Stephen Cheshire, talking about whether delay damages are an exhaustive remedy or not. And what he's saying is increasingly seeing Z clauses that state that the amount under X7 is not an exhaustive remedy. In his view, this is a pernicious practice. Do I have a view? I do have a view, and I think pernicious practice is probably a good description. I mentioned at the beginning, I was trying to flog you a book with 10% off. Well, in about 4 or 5 months, there'll be another NEC book out with my name on the front, which is about compensation events. And I wrote a whole chapter on Z clauses. So a couple of weeks ago, I spent a couple of days going through many of the contracts I come across in my role as an adjudicator, looking at Z clauses. And some of them are utterly atrocious and betray a very poisoned mind in the person who's drafted them. But it is very common, I'm afraid, to see clauses that say the liquidated damages are not an exhaustive remedy. And the one that David has just been discussing too, that under clause 25.3 for key dates are not an exhaustive remedy. Now, I'm not a lawyer, so I can't advise you on whether clauses like that actually stand up against the general principle that liquidated damages are an exhaustive remedy. What Stephen's put in his message here is it allows the employer 2 bites at the cherry. It certainly does. It potentially gives them many more as well. And I think from my own experience, and that may not be representative, the vast majority of these clauses about a lack of an exhaustive remedy come from subcontracts where it's the main contractor that slipped that one in rather than the client or the employer.
Yeah. Just picking up, I'm just flicking through some of these things that come through on the meeting chat. Taking one from Rob, our own Rob Gerard there, he says it's odd that we focus so much on the cost of lateness, yet surely the flip side is beneficial to the client. So why don't we use X6 every time we use X7? Those that don't know, X6 is a secondary option which rewards the contractor a bonus for early completion. I'm just looking down, perhaps you have just attended to that question. Yeah, I address this with clients when we're looking at contract, and there still seems to be a reluctance to use X6. It's the carrot, isn't it? It's the reward, and X7 perhaps the stick. Perhaps a supplementary question, if we had time, just in the chat box to see how many people have actually used options secondary option X6. But I think there's still a reluctance to use it, particularly in the public sector.
I think there's that generally bonuses for early completion come about with projects that have a revenue stream, and that by finishing early you access that revenue stream before you otherwise would have done. Many years ago, at the start of my career, having gone into it to build suspension bridges and dams and magnificent bits of civil engineering, I was responsible for building Sainsbury's in Kettering in Northamptonshire. And that's a good example where a bonus for early completion works, because you have liquidated damages for your failure to open the store on time, but in the event you can get it open early, the store owner and operator can earn profits it otherwise wouldn't have done, and they're willing to share those with the contractor. If you have a public sector project that doesn't have a revenue stream, like a new road or a school or something like that, if you pay someone a bonus for early completion and they finish early, you're just merely putting up the price of the project with very little additional financial benefit to the client, even if there are other less tangible benefits.
I suppose the client needs to see, the money well spent if the contractor comes in early, and benefit for the client. question at 1340 here from Sean, or maybe a point. It says, Patrick David, personally, if delayed damages are 0 per day, I would recommend stating them as such to negate confusion. View question mark. Yeah, I think that's a good point, Sean. If the intention of the client is that delayed damages are not to apply, and that neither are general damages or liquidated damages, clear words would be required, and I think that's reasonable advice there. Patrick, what do you feel about that?
That wonderful legal phrase, for the avoidance of doubt, that if the parties genuinely intend there will be no sanction for the contractor's failure to finish on time, and that they fully intend it to be 0, nil, no pounds, free, call it whatever you will, they should put clear words to that effect in the contract, and then there's no scope for misinterpretation later, because we often find ourselves getting into contract when we're all friends and we're all happy and we're all positive. And if and when your project goes horribly wrong, that's when people go scurrying to the words and saying, well, we might write this another way, we might see this a different interpretation. If you want to agree something like that, particularly if you're the one intending to rely upon it, make sure it's written in clear words in the contract somewhere.
Yeah. Did you pick up any more questions from the chat? I'm just still scanning through them, Patrick, from when I was actually talking. I see quite a bit of discussion on the capping of delayed damages. It seemed to be quite a popular topic.
The capping of delay damages, if I can be controversial, I don't think it's a good idea at all, unless the client's costs for late completion are capped at some point. Why would they agree to cap them? Now, one of the reasons they might agree, and I think somebody's referred to this in the chat, is if the market will not support a contract that has unlimited liquidated damages. And I worked on a project about 5 years ago, the construction of a very large waste treatment plant for a local authority, where the contractor had liquidated damages of £110,000 a week being deducted for over a year, whilst they struggled to prove that the plant worked to the specified throughput and quality criteria. They were actually writing a check to the employer every month, not the other way around, because the amount of money that was being taken as liquidated damages for delay greatly exceeded the small amounts of billable work they were actually doing. Now, that contractor said after the event they would never sign a contract of that nature again. So if you are a client looking to put out a contract with unlimited liquidated damages, you have to bear in mind that there may not be 4, 5 or 6 contractors who are willing to provide you with a decent tender that complies with that particular requirement.
Okay, I think we're not far approaching the end of our time slot today. If for some reason we didn't get to answer your question, or you'd like to discuss it in more detail, our contact details are available on the first slide. If not, contact us through the NEC Direct. I've been asked just to give a reminder as our closing points that the conference continues tomorrow and indeed on Wednesday. There are sessions in the morning and afternoon. Tomorrow there's a cross-sector session. Amongst others, there will be the Institute for Workplace Facilities Management and AstraZeneca. Peter Alexander from AstraZeneca talking, and the Pipeline Industries Guild. In the afternoon, there is, I suppose, an extension of some of the things we've been talking today, really, about programs, certainly in relation to a completion date, but a programming workshop in the afternoon. And then on Wednesday, there's an international flavour to the morning, following the NEC Awards, presentations from the Hong Kong Development Bureau, Ian Hastings from the Square Kilometre Array Observatory, talking about the project and the telescope and the Dispute Resolution Board Foundation. In the afternoon, there is a panel discussion on dispute resolution in the context of dispute avoidance boards on international and engineering projects. Okay, that's almost taken us nicely to 2:30, which I think is our finish time. So thank you all for joining us, and I'm sure we'll see you again soon.
Thank you very much, everybody.
Thank you.